How I feel, sun in the sky. You know how I feel, breeze drifting on by. You know how I feel. It's a new dawn, it's a new day, it's a new life for me, and I'm feeling good. I'm feeling good. Fish in the sea, you know how I feel. River running free, you know how I feel. Blossom on a tree, you know how I feel. It's a new dawn, it's a new day, it's a new life for me, and I'm feeling good. Dragonfly out in the sun, you know what I mean, don't you know? Butterflies all having fun, you know what I mean. Sleep in peace when day is done, that's what I mean. And this old world is a new world and a bold world for me. For me. Stars when you shine, you know how I feel. Scent of the pine, you know how I feel. Oh, freedom is mine, and I know how I feel. It's a new dawn, it's a new day, it's a new life. It's a new dawn, it's a new day, it's a new life. It's a new dawn, it's a new day, it's a new life, it's a new life for me, and I'm feeling good. I'm feeling good. I feel so good. I feel so good.
Hi, and welcome. My name is Jennifer Weichel, and I am the webinar coordinator for the Hughes Law Firm. Welcome to the Safer at Home Wills and Trust 101 webinar. Today, your speaker is attorney Garrett Anderson. Since 1974, the Hughes Law Firm has helped over 80,000 Coloradans plan for their future with wills, trust, and advance directives. Today, Garrett will share the secrets of great estate planning so you can plan wisely for yourselves and your family. In a moment, we'd like you to please review the case study slide as Garrett starts his presentation. If you have any questions during the webinar, please feel free to contact me at 303-409-3563 or use the chat button during the webinar. As an attendee, chat will be in the controls at the bottom of your screen. Without further ado, please welcome Garrett.
Thank you, Jennifer. And thank you all for joining me this evening. Let me introduce myself again. My name is Garrett Anderson. I am one of the attorneys here at the Hughes Law Firm. I want to thank you for joining me tonight. This is a live webinar tonight to go over what we call Wills and Trust 101. It's a safer at home aspect here to go through estate planning here. And tonight, this is presented through Colorado Credit Union. And tonight we have Sharice Scott with us here through Partner Colorado Credit Union. And Sharice, how are you doing this evening, ma'am?
I'm doing really well, Garrett. How are you?
I'm doing good. I want to thank you again for allowing us to present our Wills and Trust webinar this evening here. But with that said, I think you wanted to say a little bit to our members this evening here.
I do, Garrett. Thank you so much for those that took time out of their schedules to be a part of this live webinar. We really hope that we provide information. And I want to thank Hughes Law Firm for making time to also be here this evening. Garrett, thank you so much. I know that this is information that members really need, and we're really happy that you're able to provide it. So I will list all my information as well in the chat. Again, my name is Sharice Scott. I handle all of the financial education for the credit union. So if you need anything in regards to this or just anything that we've ever done, or if you have a question for the credit union, I'd love to answer that. So I'll swing it back to you, Garrett. And again, just appreciate you for doing this evening. Thank you so much.
You're most welcome. And thank you again for allowing us to present this very important subject area of estate planning here. So as Sharice stated, we're going to be going over estate planning tonight. Here is our primary focus is education. Education on how to do proper planning when it comes to you and your loved ones to make sure that when things happen, either by incapacity or by death, that we're trying to make this as smooth as possible to get your affairs in order. What we like to say, trying to get our ducks in a row here as we go through this here. But as Sharice stated here, is that if you have questions either for the Hughes Law Firm or for Partner Colorado as well, is that there's a chat button there that you can speak to us as we go through this process. And as we mentioned, this is a live webinar this evening. But with that said, this evening, my webinar is going to take just about an hour here. I'm going to go through many different subject areas tonight. I'm going to talk about wills, trusts, probate, when we go through probate. How we try to avoid probate. We're going to talk about guardianship, conservatorships, how we try to avoid those processes using power of attorney. So we're going to talk about financial power of attorneys, healthcare power of attorneys, advanced directives, HIPAA release forms. In addition to that, this evening, we're going to be also talking about asset protection. Asset protection in two different manners. First and foremost, asset protection for your loved ones, meaning when that time comes and you pass on, how we can make sure that these assets you worked very hard for get to your loved ones in a very specific, strong manner to give them asset protection. Asset protection from lawsuits, maybe asset protection from divorces, keeping those assets in the blood lineage whenever your children pass away, going to your grandchildren, maybe special needs aspect, minor children. Or perhaps protecting those assets from your children themselves, meaning if you have a son or daughter that may have a drug addiction, an alcohol addiction, fiscally irresponsible, over-controlling spouses, we can make sure we can do very strong planning to make sure that we have control over those assets when that time comes and you pass away, to keep it with them. In addition, we'll talk about tonight asset protection for you, meaning when that time comes and perhaps you have to deal with long-term care issues, a nursing home, how we can make sure that this money that you worked very hard for doesn't have to be spent down to basically nothing before you may be eligible for long-term care Medicaid. So we'll talk about Medicaid and when we deal with Medicaid and how we can do planning around that aspect here. So with that said, let's get started. Whenever I deal with an estate plan, everyone is different. Everyone tonight has different family dynamics, different goals, different objectives here. But when I do education, I need to have someone to start with to do planning as we go through this process to make sure that things are taken care of as we go through this process. So with that said here, what we're going to be doing here, if I can get my little slide working here, oops, I think we got logged up here a little bit here. Oops, gotta love live webinars here. Well, things just kind of get moved or logged up as we go through that here. Hang on one second, we're going to work on this just briefly here. There we go, okay. So with that said, oops, now it's working on me. So with that said, my next slide here, now I got my little clicker working. My next slide here is going to be talking about a case study, a family that we're going to use to help go through many different types of issues that we are going to be dealing with. Now, obviously, probably not all of these issues are issues you have to deal with, but John and Mary are going to help us deal with some of these. So in this case, let's talk a little bit about John and Mary. We have our list here about John and Mary and what's going on in their lives. What we're dealing with here is an elder couple that's both on their second relationship. Here we have, in this particular circumstance, John. John has a daughter, Alice. Alice here is very fiscally responsible. I'm not concerned about bequesting assets to her. Who do you think I might be concerned with when it comes to Alice? If you're looking at this and saying, well, it looks like Rusty, Garrett, is going to be one of our concerns, you're absolutely correct. One of John's primary goals was make sure when that time comes and he passes away, that when the assets get to his daughter Alice, that they stay with her. That if they get a divorce, they stay with her. If she dies, they stay with the grandkids. That they do not end up in Rusty's hand, who may be fiscally irresponsible, lose those assets, gets remarried, has a bunch of stepkids. All of a sudden, all this money that John worked for is ending up in people's hands that he never knew. If you're dealing with a circumstance that you're trying to preserve those assets in the blood lineage here, we're going to talk about how we can get that accomplished. In addition, we have Mary now. Mary has a son here, Bart. We love Bart dearly, but Bart's a recovering alcoholic. What do you think might happen if we bequest a large amount of sums to someone like Bart? Exactly. He may fall off that wagon. Here, he's worked very hard to keep his sobriety. The last thing we want to do is to use this inheritance as a carrot that may kick him off that wagon. So if you're dealing with a circumstance like Alice, an over-controlling husband, like Bart, that may have a drug addiction, an alcohol addiction. We have some special needs issues here dealing with some of our grandchildren, Danny. You have to realize there's very specific planning that we need to do to make sure that these assets stay with them as we go through this. Next, we have assets here. That's the bottom of our little sheet here, showing exactly what, in this case, they have. Assets are important because assets will detail when we go through one of our first subject areas that we're going to be dealing with this evening, and that is probate. Here on in, anytime I use the term probate, I want to have something come to your mind, and that is court. Who benefits if we go to court? Where if you're saying, Garrett, you benefit, the attorney, you are absolutely correct. You have to realize what my goal is as the estate planning attorney is to try to avoid court if at all possible. Trying to do what we look at here as the proper perks of doing estate planning, which is protecting assets while you're alive, when you become incapacitated, protecting assets whenever you pass away from additional attorney's fees, perhaps protecting assets if you go into a nursing home, protecting assets for your kids. But all this comes through education. That's what all of you are taking time out of your evening this evening. And once again, thank you for joining us, is taking time to learn about doing proper estate planning. And it comes through becoming educated, employing perhaps professionals. We want to make sure we don't have to pay any additional taxes if we don't have to. We'll talk about taxes. We need to keep current though. Please be aware. Estate planning is not a one and done type of circumstance. It's just not signing your will, putting in your safe deposit box, and forgetting about it for the next 30 years, which I guarantee there's a couple of you tonight that have done exactly that. We have to keep current. Things change. Laws change, tax law change, families change, family dynamics change, your goals, your objectives change. We need to make sure that when things happen, things are in place that are current. And one thing we want to do is make sure we avoid no additional court costs. We don't want to have to go to court and spend money on the courts, on publication fees, or court fees, or specifically attorney's fees. We'll talk about this as we go through this. So let's get into one of our first subject areas tonight. Not going to spend a lot of time on it. Inheritance tax, also referred to as death tax. Not going to spend a lot of time on it because of this right here. Currently, you're allowed to bequest onto your beneficiaries, if you are single, just over $12 million. If you are married, we have what's called portability now in the tax law. Now we are allowed to double that inheritance tax to a married individual and double it to $24 million upon the death of the first spouse if a proper tax return is filed. So for a single individual, 12 million, married, 24 million. So as you can probably guess, for the vast majority of us, it's not something that's probably going to affect us. To be honest, 99% of us now are not going to be dealt with inheritance tax issues. But on here, this says federal estate tax. What about state inheritance tax? Does Colorado have a separate inheritance tax? And in Colorado, we do not. We follow these federal guidelines. But just because we probably won't be dealing with inheritance tax for the vast majority of us, you have to realize if you do improper planning, there are additional taxes that can come into play. gift tax, which then could force capital gains tax. So we'll talk about how that may work here, especially when we get into our joint tenancy aspect of our webinar tonight. So with that said, let's talk about a subject area that probably will affect 99% of you tonight, and that is probate. So I use the term probate. So what's the first thing that's come to your mind tonight? Exactly. If you're saying court, you're right. Here in Colorado, we like to say we have two types of probate: death probate and living probate. Both of them court processes we have to deal with when something should happen: death or incapacity, living probate. We're going to deal with them separately. First off, death probate. So my first question to all of you tonight is, we have John and Mary. We're going to talk about what probate is when we go through it, but we're going to ask you this question first off, is that we have John and Mary, and let's say Mary is the first spouse to pass away. So Mary dies first. If Mary passes away first, how many of you believe, before we really get into probate and what it is and when we go through it, how many of you looking at this off the top of your head thinks that, yes, if Mary does die first, that, yeah, her estate will probably have to go through probate? There's a little clicker on your Zoom where you can press to wave your hand. So go ahead and you do that if you would like to, showing us how many think that, yes, if she does pass, that we would go through probate first. All right. How many are looking at this and saying, no, Garrett, I don't think your estate will go through probate? Okay. And how many are looking at this and saying, Garrett, you know what? I have no idea. That's why I'm here tonight. There you go. Don't worry. I'm going to teach you what probate is and when we go through it. So with that said, what is probate? We got to answer that before we can determine whether or not we go through probate when Mary dies. So the question is, if Mary dies first, where we go through probate? In order for us to answer this, we need to know what probate is. What is probate? Well, probate is the legal process that we must go through here in the state of Colorado in order for the executor, the personal representative, the person that you nominated in your will to handle the estate upon your passing, in order for this individual to obtain legal title to your assets. So he or she has the legal right to pass those assets on to the individual you wanted those assets to go to. Once again, probate is the legal process in which your estate must go through in order for your personal representative, the executor of the estate, in order for them to have the legal ability to get the asset out of your estate and onto the individuals that you wanted those assets to go to in your will. But we only have to do this when, in fact, we own certain types of assets. We only go through probate in Colorado when, in fact, we own real estate and or more than $74,000 in assets that have not been disposed of otherwise. Once again, we only go through probate in Colorado when, in fact, we own real estate and or more than $74,000 in assets that has not been disposed of otherwise. What does that mean? That means not having a beneficiary designation on that account. So with that said, in order for me to answer the question or not we go through probate, I need to look at what? Exactly. I need to look at Mary's assets, because that's going to determine whether or not we go through probate. Now, some of you tonight may be looking at this and say, wait a second, Garrett, talking about assets, but you didn't even mention whether or not she has a will. Because if she has a will, in fact, in place, that we don't have to go through probate. Is that correct? If you have a will in place, does that mean we avoid probate? The answer is no. You have to realize your will has no legal effect whatsoever on whether or not your estate will go through probate. It's all about what you own and the type of asset it is. So you may be asking, well, what is a will good for then? What is a will? Well, a will is a very important document, a legal document, but in all reality, it's a very simple document. A will is a document that states to the world where your assets go upon your passing, and it's a document that nominates someone to handle that process for you at that stage. That is all a will does. States to the world where your assets go, and it nominates someone to do this for you whenever you pass away. A will is not a living instrument. What do I mean by this? What I mean by this is it's not alive. It cannot take legal title to your asset. So in all reality, a will is just a piece of paper. And in reality, it doesn't do anything until you pass away. And then when you pass on, then the will goes into effect, nominating who can get into your estate and stating where those assets go. So with that said, In order for me to answer the question or not Mary goes through probate when she passes away, I don't care if she has a will, in fact, in place. I care about what she has in assets and how they're titled. Behind me, I have a bunch of buckets. Well, my buckets, you may be asking, what are they here for? My buckets help me teach. I'm a very visual individual, and my buckets help me conceptualize some of these concepts that we're going to be going through. The first is probate. So this bucket here is representing what we call a probate estate. An estate. Each and every one of you tonight, whether you're married or not, has one of these buckets. And based on what's inside of the bucket, assets, will determine whether or not we go through probate. So what I'm going to be doing now is I'm going to build Mary's probate estate. So therefore, at the end of this exercise, we're going to make an informed decision on whether or not we go through probate. So as I go through this, though, in the back of your mind, I want you to build your own imaginary bucket. So therefore, at the end of this exercise, you're going to be able to make an informed decision on whether or not your estate is going to go through, probate. But right now, we're focused on Mary. So let's look at what assets Mary may have. The first asset that she has is, in this case here, real estate. The real estate is going to be represented by my little yellow ball. In this case here, this is going to be the residence, and this is going to be, in this case, the vacation property, the second property that she has in Hawaii. So in this case, what I'm going to do is I'm going to take her real property and I'm going to put those assets in her probate estate. I want you to think about if you own any real estate. Think about where it's located at. Think about how it's titled. And then I want you to put that into your probate estate. Build your estate, just like I'm building her estate. Next, we have the mutual funds. Now, the mutual funds are going to represent, in this case, all of your non-tax deferred, non-qualified investment account. So this is your stocks and your bonds, your brokerage account, your investment account that you may have that's not part of your retirement account. That's what my little maroon balls will represent tonight. They're going to represent all of our investment accounts. I'm going to have you transfer those into your probate estate. Think about which ones you may have. Think about where they're located at, how they're titled. Put those into your probate estate. Next, we have some CDs. Now, the CDs are going to represent all of our liquid assets. So this is your checking, your savings, your money market, your your CDs, all of your liquid cash assets that you may have over at Partner Colorado Credit Union in this case. So in this particular circumstance, that's what our little green balls will represent. They're going to represent our checking, our savings, our CDs, our money market account, our liquid assets, the U.S. currency, cash. So what I'm going to do now is I'm going to transfer those into Mary's probate estate. Now, in this particular circumstance, I want you to think about what you have in cash assets. Think about where they're located. Think about how they're titled. Are they joint? Are they in your name? In this case, ours are jointly owned between John and Mary. Next, we have some IRAs, annuities, life insurance. I'm going to group these last three together. Why am I going to group these last three together? I'm going to group these last three together because these last three types of assets are the types of assets that are going to be disposed of otherwise. What do I mean by this? What I mean by this is having a beneficiary designation on that account. So whomever the beneficiary is going to receive those assets. So if you have an IRA, a 401k, a TSP account, an annuity, a life insurance, I want you to think as who have you listed on those accounts as your beneficiary? Who is your primary beneficiary? Who is your contingent beneficiary? And if you do not know who you've listed as your beneficiaries, what's one of the first things I want you to do tomorrow for me? Exactly. I want you in this particular circumstance to call them up, find out, and place a beneficiary on those accounts. All these three types of accounts that we just spoke about should always have a proper beneficiary designation on the account. So what we've been able to do now is basically build Mary's probate estate. Hopefully you went through all of your assets, thought about where they're located at, how they're titled, are there beneficiaries on them, and hopefully you've transferred those into your probate estate. So now we're going to make an informed decision on whether or not your estate will go through probate, but we're focused on Mary at the moment. So the question was, if Mary dies first, will her estate have to go through probate? So now, how many of you are looking at this and are saying, yes, her estate will have to go through probate? Okay. How many of you are still looking at this saying, no, her estate will not go through probate? Okay. So with that said, then, what is the correct answer? Well, the answer actually is no. Her estate will not go through probate when she dies. Why is that? because of how the assets are titled. In this case, all of Mary's assets are what? Jointly owned, which means that when she dies, the assets will just naturally flow onto her husband, John. Now, please be aware, means nothing about the marital status. So some of you may be looking at it and saying, well, they're married, that's why we're not going through probate. No, the marital status doesn't mean that. It's just how the assets are titled, which normally means that when you're married, a lot of times our assets are jointly owned. But let me change this up. Let's say that the condo is in Mary's name only, and now Mary passes away. Now will her estate have to go through probate? Yes, because she has now in her probate estate an asset, real estate in her name only. And what state are we going to have to go through probate then? If you're saying Hawaii, you are correct. You will go through probate in every state that you own real property in. Let me change it up again. Let's say now Mary's passed away, everything's flowed on to John. And now John passes away. Now we're going to go through probate. Absolutely, because now everything's in John's name. The question now is, in what state are we going to go through probate when John dies? If you're saying we're going to go through probate in 2 states, you are absolutely correct. So now, what do you think the cost is to the estate to go through 2 separate probates? If you're saying double, you are absolutely correct. Our goal is to avoid this. Our goal is to avoid those court costs, those attorney's fees. We want to smooth this out if at all possible as we go through this process here. So with that said, how's one way of doing that? Well, this right here. You may be saying, Garrett, whenever Mary passed away, everything was just joint with John. That sounds like a good plan to do, because that way if John goes out and maybe puts Bart and Alice on the deed to his house as a joint owner with the right of survivorship, we'll avoid court for those purposes. Is that correct? If you do joint tenancy with your children, you'll avoid probate? Well, that is correct. And can you do that? Can you put your children's names on the deed to your house? Absolutely. The question though is, should you do joint tenancy with your children? And 99% of the time, the answer is no. We do not want you doing joint tenancy with your children or your loved ones in that respect. Why is that? Well, when I put someone else's name on the deed to my house, what have I done? I made them an owner. As an owner, they have all the same rights and obligations in that property as I do. And that's why we have down here in quotes, the poor man's estate plan. I don't call joint tenancy the poor man's estate plan because this is what someone does when they have no asset. We call this the poor man's estate plan because this is what can occur to you if you do improper planning. It can make you poor or it can make your children poor. And let's talk about the big 3 pitfalls of this. First and foremost, loss of control. Well, if I put Bart and Alice on the deed to the house after Mary passes away, and if John decides that he wants to sell, let's say, the Hawaii property, can he just turn around and sell it? No, because if he's placed Bart and Alice on the deed to the house and he wants to sell that property, how many signatures is he going to have if Bart and Alice are joint owners with right of survivorship on that property? Exactly, all 3. So now I've lost control to someone else. Now you may be saying, Garrett, I understand, but I completely trust my kids. I have perfect kids. Hopefully everyone tonight does have perfect kids. But remember, no one is perfect. And that's why we have exposing that asset to their issues as number 3 on here. Because let's say Bart is on the deed to the house. Let's say one night Bart decides, to leave his house. He goes to a local bar, a local tavern. He falls off that wagon. He becomes highly intoxicated. He thinks it's a great idea to get back in his car and drive home. So he does. On the way home, he runs a red light, gets into a car accident. In this particular circumstance, kills someone. The family of the individual that he killed turns around and sues him for everything that he owns. Can that lawsuit now come after, in this particular circumstance, your house if Bart was on there? Absolutely. Now we have lost that house to your son's issues, his lawsuit, his bankruptcy, his divorce, his issues come into play, and that could affect our asset that we worked very hard for. Once again, no one is perfect. You may be saying, well, Gary, I put his name on there. That's not a problem. I don't mind the loss of control. He'll do what I want him to do. And I don't have to worry about him getting sued, things of this nature. Proper estate planning is trying to deal with the crystal ball the best that we can. The worst of things can happen to the best of us. Even your perfect child could still get in their car, drive, they're not drinking, but they accidentally run that red light. Could happen to the best of us. They'll accidentally run the red light, they'll get into a car accident, still kills them. Not going to be a criminal offense, but it's still going to be a civil offense that could affect your son and his assets, which now includes your house because you placed them on that property. In addition to that, we want to make sure that your son gets the best tax benefit that we can possibly give to him at that particular stage. So in this particular circumstance, we want to make sure that whenever you pass away, that your loved ones, your beneficiaries, your children, get their inheritance tax-free. And for us to do that, we need to make sure that it is an inheritance, which means that when it gets to them, it goes through the inheritance tax law, which says that when an individual receives an inheritance, they will get what's called a new step up in basis for tax purposes, which means they will receive those assets that you gave to them outside of IRAs to them at the fair market value at the time of your passing. So if your house is worth $500,000 whenever you die, your children will receive that house at $500,000. That's their new basis. And if they sell that property, they're going to sell it at fair market value, which is what they got it for. So therefore, there was no capital gains to your children at that stage. They received their inheritance tax-free. But if you place their name on that property, well, that property is going to be deemed as a gift now. That is not going to be deemed as an inheritance. So what's going to happen is they lose that step up in basis, and they're now going to take that property at what it was worth whenever you originally bought it. So if you bought it for $100,000, but when you die, it's worth $500, what's going to happen is they're going to take the basis at $100,000, but they're going to sell it for how much? Exactly, fair market value, which was $500,000. So now they're stuck with this hypothetical of a capital gains of $400,000. We do not want you doing this type of planning. With that said, now let's move to the other aspect of probate, incapacity probate, living probate. Making sure that if that time comes and you have a stroke or heart attack, dementia, Alzheimer's, that we have documentation in place to make sure your loved ones can make proper decisions for you on your behalf. Doing what we like to say, getting our ducks in a row through a disability toolkit. These 4 documents I'm going to speak about are documents that every single one of us must have. Whether we're 18 years of age, emancipated, or 108 years of age, every single one of us tonight must have these 4 documents. The first is a properly prepared healthcare power of attorney. Why do we need this? You have to realize that just because you may be married, just because you may have children, doesn't give anyone the authority to make healthcare decisions for you. If we do not have a properly prepared healthcare power of attorney in place, we're going to have to go to court and get something referred to as a guardianship. A guardian is a court-appointed person who steps forward to make healthcare decisions for you when we do not have this document in place at that stage. But we can avoid that entire court process if we just have a good, solid healthcare power of attorney in place, authorizing someone to make healthcare decisions for you when you cannot do it for yourself. And whenever you do these documents, we're going to talk about the 4. First one, healthcare. Make sure that you make informed decisions. Think about who you're putting into these roles to make decisions for you as we go through this. So important that you put appropriate individuals in place. And then we want you to educate them at that point. Let them know what your wishes are. Let your family know who is in charge at 2 o'clock in the morning. Making sure that all of our family members can find out how you're doing. That's what HIPAA is. HIPAA is a federal law that authorizes doctors the authority to release information out to certain individuals. Making sure, though, that if, God forbid, you're placed on life-sustaining procedures in either a terminal or a persistent vegetative state, that we have proper documentation in place showing what your intent is, meaning how long you'll be left in that position. And then when you're taken off life-sustaining procedures, whether or not you want artificial nourishment and hydration, to be continued given to you at that stage. What you're trying to do is educate your family. So if they're placed into this position, that burden of deciding when to allow you to pass away has been taken away because you've made that for them, because it's about you and what your intent is. But we want to make it easy for them, give them the ability to do what needs to be done. And that's also dealing with finances. Here in Colorado, we separate our healthcare power of attorney from our financial power of attorney. If we do not have a properly prepared healthcare power of attorney, we're going to have to go to court to get a guardianship. If we do not have a properly prepared financial power of attorney, or what we're going to talk about here in just a moment, a properly prepared trust, then we're going to have to get something referred to as a conservatorship. A conservator is a court-appointed person to step forward to make financial decisions in this particular circumstance for you when you're unable to do this for yourself. So important that we have all four of these documents in place. Like I said, something all of us have to have. It's our base. A base to our house, which is our estate plan that we're trying to build here. And as you put these documents in place, educate your loved ones. Let them know who's in charge, who deals with your finances, who's dealing with your health care. Because guys, it's going to happen. If you live long enough, at some point in your life, you are no longer going to be able to make decisions for yourself. It's just a fact of what we're dealing with in today's society. Next, what we want to do though is perhaps build the strongest possible way of managing assets. And that's what a trust usually allows us to do. So what is a trust and what advantage of maybe looking at doing a trust versus just a good simple will in an estate plan? Well, trust is a contract. That's all it is. On its simplest terms, it's a contract. But the type of trust that we like to look at is something called a living trust. What do I mean by this? What I mean by this is it's going to get its own bucket. Remember, while you're alive, every single one of us has one of these buckets, a probate estate. And remember, this is what happens whenever you pass away. We have your will, and this is what your will is going to do. Your will is going to go right on top of this estate. So therefore, then in this particular circumstance, we're going to have to get permission to get into this estate to transfer those assets out. And we have to get permission if inside the estate there's what? Real estate and or more than $74,000 in assets that has not been disposed of otherwise. So therefore, I really want this estate to be what then? Well, I want this estate to be empty, this probate bucket to be empty. So therefore, whenever that time comes and you pass away, whether we have the will or not going to effect, it's not going to make any determination because there's nothing inside of it. We want to make this very easy. So these assets got to go someplace. That's what a living trust allows me to do, because a living trust, as you're guessing, is alive. It's its own person. And because it is its own person, it gets its own trust. Revocable living trust. This is a contract. Contract, if you are married, between you and your spouse. If you're single, contract between you and yourself. A contract with very specific terminology on what's going to happen while you're alive, what's going to happen if you become incapacitated, and what's going to happen when that time comes and you pass away, on how we get the assets to our loved ones. There are three roles that we build into this trust. The first role that we're going to build to this trust is what's referred to as the trust maker. This is the person who creates your contract, your trust. Who is the trust maker of your trust? You are. You're the one creating this instrument. The second role you're going to serve as is what's called the trustee. This is the person who manages this trust. And then this trust will have two types of trustee, something called a disability trustee and something referred to as a death trustee. This is the person who's going to manage, in this particular circumstance, the assets that are built into this trust. The third role that we build into it is what's called a beneficiary. Who's the beneficiary of your trust while you are alive? Exactly, you are. And then we're going to have what's called death beneficiaries at that stage, where the assets are going to go at that particular point. But this is one of the strongest ways that we can manage the assets, because then if something does happen, the assets are right here. We have a trustee that can immediately step in to manage these for you. We have a stroke or heart attack, dementia, Alzheimer's. We can manage the assets. And then when you pass away, there's no court processes I have to worry about, because nothing is here. Everything is where? Exactly, in our irrevocable trust. But one nice thing about our revocable trust is that it's going to allow us to do some asset protection. First off, it's going to allow us to maybe build protection in the instrument to protect it for your children from themselves or maybe from the outside world. Those lawsuits, divorces, keeping it in the bloodline, special needs, minor children. So we're going to be looking at this type of trust. There we go, got a little guy there shooting up. We're going to be talking about our Descendants Bulletproof Trust. This is the instrument here that we're going to use to protect those assets. So how is this going to work here? Well, we have our revocable trust. We've worked with this trust over our entire life. We've properly managed it, meaning our assets are part of this trust. They're not over here. But what's going to happen now is Mary's going to pass away, perhaps. Nothing much we've got to do. Everything stays in the trust for the benefit of John. John's still in charge. But now John passes away. Or if we're looking at doing asset protection for the kids, this is what's going to occur. That instead of, in this particular circumstance, a check being written out directly to Alice, this is what's going to occur. A check is going to be written out to Alice's trust. What do I mean by this? What I mean by this is our trust here is going to do this. We're going to have this trust build trust funds for our loved ones. So therefore, instead of a check going to Alice's personal name, which once it does, she owns it. That's not what we really want, because if she owns it, then her issues come into play. Her lawsuits, her divorces, going to people that we don't know, special needs. Well, what we want to do now is instead make sure that the money is still there for her care, but instead it's not in her personal name, because if she doesn't own it, then the asset is protected. So what's going to happen is instead of this trust writing that check, it's going to go to these trust funds. And so I'm going to split my assets here. So I'm going to do a 50-50 split. Now, the question to you tonight, though, is, are you required to teach or treat your children equally when you pass away? The answer is no, you are not. So we're going to give 50% to Alice, 50% to Bart. In this case, we'll treat them equally. Now, did I have to go through any probate to do that? No, because in this case now, there were no assets where? In her probate estate. They were all here in the revocable trust, which created trust funds for the two kids. Now money went to Bart's. This is what's going to happen when Bart gets it. Lids are going to go on here, making these trusts what? This lid is going to represent making this trust irrevocable. So when the asset gets to, in this case, Bart, the assets are not going to be owned by Bart. They're going to be owned by what? Bart's trust. For the benefit of whom? For Bart. Exactly. So therefore, for the rest of his life, this is what can happen. Assets can still come out of the trust for his care. But when that time comes and something should happen, he goes through a lawsuit. This is what can happen. Based on the terminology of the trust, we've been able to build around a little bulletproof vest. So now we can just shut this off. Those assets cannot be attached. He goes through a divorce. Same thing, we just shut this off, and that divorce cannot come in to take those assets. And then when he dies, whatever's left over in this trust will not go to, in this case, Bart's wife. Instead, these assets will go where? Exactly, to his children, your grandchildren. It's keeping the assets in the bloodline. This is one of the strongest ways that you can possibly leave assets to our loved ones. But next, we want to talk about how we can make sure there's assets there. That's using this trust, what we call a lifetime bulletproof trust. This is a trust that we look at sometimes when we're trying to protect assets if an individual happens to deal with long-term care costs, i.e. skilled facility, a nursing home. What do you think it costs on average to be in a skilled long-term care facility here in the state of Colorado on a monthly basis? If you're saying to yourself about $8,000, you're correct. That is the average cost, just over $8,000 to be in a skilled facility here in the state of Colorado. Who pays for that? If you're saying you do, you are correct. Does your health insurance pay for you to be in a nursing home? It does not. Does your Medicare pay for you to be in a nursing home? It does not. Every single facility in the United States is private pay. They have you pay first out of your pocket. But if we're spending $8,000 a month, trust me, it doesn't take long before that eats everything up. And then we have a program called Long-Term Care Medicaid. So what is long-term care Medicaid? Well, first off, Medicaid that we're dealing with here is not Medicare. Medicare is the federal health insurance. We're all usually eligible for it at 65. It's our health insurance. And a lot of times then we supplement it with a supplemental Medicare health insurance package. Medicaid is not health insurance. Medicaid is the state and federal program that will kick in to pay for your long-term care bills, your nursing home costs, when you're unable to do it for yourself. It is asset-based. What do I mean by this? What I mean by this is you're eligible for it when your assets are at a certain level. If you are married and we're dealing with one individual in a long-term care facility and one perhaps living at home, what's called a well spouse, then that married couple can have over $137,000 plus a house plus a vehicle. If you are single in a long-term care facility, you're allowed to have just over $2,000 plus a house plus a vehicle. If you are married, but both of you are in a long-term care facility, then you can have just over $3,000 plus a house plus a vehicle. Now, how many of you feel tonight that Medicaid is a free program? All right, hopefully no one is saying yes, because Medicaid's not free. What do I mean by this? What I mean by this is Medicaid is authorized to do what's called a state recovery, meaning that when you die, and if you are on Medicaid, Medicaid has the right to be paid back from your estate on what they spent out on your care. So what's the one asset that you may still have and be on Medicaid? Exactly, your health. What happens is when you pass away, Medicaid has the right to do an estate recovery through probate to place a lien on your property as a creditor to recoup the amount of money that was spent out on your care, leaving what to your beneficiaries at that stage? Perhaps nothing. So for a lot of my clients, that's just not acceptable. They say, Garrett, you know what? Especially this house that I worked very hard for, I want to make sure that's protected. If I go into a nursing home, I want to make sure the equity is protected if we sell it. And I want to make sure, though, in this case, when I die, if I'm on Medicaid, that they can't come take that house away from my kid. I want to preserve it. So how do we do this? Well, on its simplest terms, we're going to get it out of your name. Because if you don't own it, Medicaid can't come after it. But is it that simple? No, it's not. Why is it not? Because Medicaid knows you can do this. So Medicaid has a rule saying, hey, when you apply on the date of application, we, meaning Medicaid, will go back exactly 5 years to see if you've made any gifts. And if you have, Medicaid will penalize you for making that gift. So how do we do Medicaid planning? Well, I'm going to gift your asset away and wait how long? 5 years. Is it really that simple? No. Because I've got to get that asset out of your name, but I've got to do it in a proper manner. Which means that I don't want you to just turn around, and some of you may be thinking about this, is turn around as gifting your house to your son. Because if you do that, who owns that house? Your son does. So what happens if your son gets mad at you one night? Can he kick you out of your own house? Absolutely. What happens if he gets sued? He goes through a lawsuit. He gets a divorce. What could happen to your house? Exactly. We could lose it. Because his issues will come into play, taking his assets, which now is your house. In addition to this, you may be saying, none of that's going to happen to my son. Perfect child. But with that said, though, the worst of things can happen to the best of us. What happens if I gift my house to my son, 6 months later, he has a massive heart attack and he dies? What could happen to my house? Exactly. I could lose it. It's going to go through his estate. His estate goes maybe to his wife. Maybe no problems with the wife, but she's in her 40s, 50s. He dies, she's probably going to do what? Move on in life. Remarry. Who's she going to remarry? I don't know. Rusty, perhaps, who's all about what? Exactly. Money, 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 which now includes my house. So now I've exposed my house to my children's issues. But I still need to make a gift if I want to protect it. So what am I going to do? Well, what we're going to do is perhaps build another trust. That's what this little bucket's going to represent. It's going to represent what we call a lifetime bulletproof trust. So what we're going to do is we're going to take this house. Where's my house here? Let me get it here. All right. So here's our yellow ball. This is our residence. What I'm going to do is I'm going to take that house, put it in this bucket. As soon as I do this, now another lid is going to go on this bucket. Making this bucket what now? Exactly. Irrevocable. So I've been able, with the terminology built into the trust, to do this, to build around it another little bulletproof vest. So now in this case here, this asset or assets that are inside are what now? Exactly, protected. So if I can make 5 years, Medicaid cannot look at this and penalize me for making this gift. And 2, when I die, I could still be on Medicaid, but I have this asset here that they cannot attach. It is a way to preserve this asset for our kids, or in this case, ourselves, for the equity. Now, with that said, what do I mean by this? What I mean by this, if we ever sell the house, this is what's going to happen. The sale proceeds do not come to me to push me over my available limit, my assets. Instead, it's going to go into the trust. Who owns the trust? Exactly. You do not. The trust owns itself. Because in this case, you cannot be the trustee, you cannot be the beneficiary, though. That will be our children as we go through this. So who should explore doing this? Well, individuals that may not be able to get long-term care insurance. Individuals that can stay out of a nursing home for how long? Exactly, 5 years. Because remember, we have to deal with that 5 years no matter what we do. We do this when we have certain sizes of estate, when we own a residence, when we have maybe upwards around $1.2 million. We do this whenever not all of our money is in our 401ks, IRAs. What do I mean by this is IRAs, 401ks, I cannot protect because they have to stay in your personal name. We do this whenever we have one family member that we trust. Why is that? Because in this particular circumstance, when we build this trust, you cannot be the trustee, you cannot be the beneficiary of this. But what's going to happen is if we can make 5 years, you go into a long-term care facility, then if the other assets are being spent down to the appropriate level, we can go on Medicaid at that point, but still have this trust sitting off to the side that my children can use and access to take care of me as needed. But when I pass away, whatever they did not touch on there, then in this case, cannot be attached through estate recovery. A very strong way of protecting these assets. Well, guys, we've gone through estate planning. As you can see, I've gone over many different subject areas this evening here, and I kind of went through a lot of this fast, and I apologize for that. But with that said, this is a live webinar, which means that I'm going to be able to answer any questions that you may have now. So here in a few moments, I'm going to tell you how to do that. Just go to the chat button and the Q&A button and type in questions, and I'm going to answer those for you tonight. But with that said, though, where do we go from here? Where we go from here now is to really look at you, meaning looking at what you're dealing with, your family dynamics, what your goals and objectives are, so we can start helping perhaps get your ducks in a row as we go through this process. So through Partner Colorado Credit Union this evening here, you're going to have a unique opportunity of coming to visit with me, or one of my other attorneys that I have on staff, at no cost to you whatsoever, for us to really get into the nuts and bolts of what should be done for you. Because tonight, hopefully, we kind of help build that kind of basis of what all these documents are that we're going to be looking at doing for you and why we have them and how they work as we go through this. But one of the biggest issues that it comes to estate planning is this right down here, procrastination. Procrastination is the name of the game when it comes to estate planning. Well, you stopped some of this evening. You've spent time tonight, taking time out of your evening. Hopefully after you all voted today, hopefully everyone did vote, but you've taken time now this evening to say, okay, what do I need to do? How are things working here? Well, now we need to focus on you. So through Partner Colorado Credit Union tonight, you have a unique opportunity of signing up for a completely free consultation. I'll express to you how we will do that in just a second. That consultation is an hour and a half. You bring old documents, bring family information about yourself, about your family dynamics, your goals, your objectives. That way we can figure out what needs to be done for you and answer questions that you may have. But through Partner Colorado Credit Union tonight, you're going to actually have a unique opportunity of taking 25% off of any of your rates at this stage. We have 7 offices throughout the metro area, from Colorado Springs to Fort Collins. We offer Zoom meetings if you are not comfortable yet meeting in person. We're able to do telephone conferences, home visits in very specific circumstances. Who are you working with? We're working with a Hughes law firm. We've been doing estate planning since 1974, and we're very proud of our experience. We like to say we've done enough estate plans for our families to literally fill up Mile High Stadium. These are some of our attorneys on staff: myself, Lori Work, Richard Hughes, Rick Best, Michael Sasson. This is our support staff. I'm very happy with our support staff. Many of our support staff has been with us for over 35 years, something that we're very, very proud of. So now I'm going to have Jennifer come on, and she's going to express to you how you can sign up for a completely free consultation and also how you can ask any questions. So with that said, Jennifer, if you don't mind coming back on for me real fast.
Hi, it's me, Jennifer, again. I wanted to thank you for attending our Safer at Home Wills and Trust 101 webinar. We appreciate that you took the time out of your day to watch us. We hope you may have learned a few things. Just a reminder, don't forget to click the chat button and type "call me." I will call you as soon as possible to set your appointment. It would be our pleasure to help you with planning your estate. We hope to see you soon.
Perfect. Thank you, Jennifer. So with that said here, what I'm going to do is now answer some questions that you have. As I go through this, though, if you would like to sign up for a free consultation, just go ahead and put in there, call me with your phone number and a time that you would like to be called, whether later this evening or tomorrow, or you can call Jennifer directly and then she can help you schedule that free consultation. But for now, what I would also like you to do is type in the Q&A any questions that you may have. So I'm going to go back and forth on my computer and answer those questions. So the first question we have tonight is, can you have the same person as your healthcare power of attorney and as your financial power of attorney? And that is absolutely you can. There's no conflict there. Is the main thing there for who you've chosen as your healthcare power of attorney and your financial power of attorney is the appropriate person, which means that this is the person that you want to do what needs to be done for you appropriately here. But there are some times where the healthcare is different than the finances. But a lot of times my clients say, this is the individual that I want doing everything. It's up to you. But once you put that person in place, also make an informed decision of who the subsequent agents will be. So you have a primary, then a secondary, and then a third as we go through that here. And then educate your loved ones. Next, in this case here, can 2 people be shared beneficiaries? Absolutely. You can put as many beneficiaries on your accounts as you so feel. In the trust, in your will, that's up to you on who you want your assets to go to. And you can list anyone, friends, charities, family members, churches. It's up to you on who you want your beneficiaries to be. Basically, think about this here is there's 2 ways of doing it. You can give dollar amounts to people, or you can do what's called a percentage splits, which means that you take 100% and you just split up those percentages however you want. Totally up to you. The next one more is, what is a beneficiary deed? We always have this question. A beneficiary deed is a very effective instrument here in the state of Colorado that allows us to place the beneficiary on real estate. So it's a deed that attaches to your house whenever you pass away. All we have to do is file the death certificate, and that house is deeded directly to the individuals that you have listed on that deed. It's a very effective instrument in certain families, when there's not a large family or when the kids get along. Because if kids don't get along, beneficiary deeds don't work very well because it's deeded directly to them. Then they got to work together as we go through that process. So with that said, it looks like those are all the questions this evening here. I want to thank Partner Colorado Credit Union once again of allowing me to present to you Wills and Trust 101 here. Teresa, I see that you came back on this evening. I'll let you say anything to your members this evening as well, if you would like to.
Just thank you so much, Garrett. I appreciate your time this evening. I appreciate any members' time that they've given to us for learning this important topic, and just thank them. And I wasn't able to put my information in the chat, so I just wanted to mention I will put it in the Q&A if anyone needs it. So
Perfect. And we'll leave this up for a little while. That way you can put that in there and they can make sure they get their information properly. So, well, thank you everyone for joining me this evening. I hope you're all safe tonight, and you guys have a great afternoon. And Thanksgiving, if you can believe it's just around the corner. So have a happy Thanksgiving. Thank you very much.
Thank you, Garrett.
Thank you.